Like and subscribe and click the bell icon to get new video updates.
Lawyers for Higgins accused rapist want case halted. Media blackout by Angus Thompson updated March 16, 2022, 6.41 first published at 11.20 am. Save login, register or subscribe to save articles for later. Share normal text size, larger text size, very large text size. Lawyers for Brittany Higgins accused rapist, Bruce Luman, are calling on the media to remove published stories about the former parliamentary staffer's allegations in the lead-up to a bid to stop the trial going ahead. Mr. Luman's barrister, David Campbell, South Carolina, told the ACT Supreme Court his client's lawyers would be writing to various media outlets seeking their cooperation to take down various articles referring to the allegations and would be asking for court orders if they didn't consent. Former parliamentary staffer Brittany Higgins went public with her allegation in February 2021. Credit, James Brickwood. We propose to write to the media today, or at worst tomorrow, and give them 7 days, Mr. Campbell said. It is likely we wouldn't have universal assent from the media for a takedown. However, media lawyer Justin Call said it was entirely unnecessary and inappropriate for such an order to be made. Juries are already prohibited by legislation, the oaths they swear and directions from judges not to do their own research, such as googling old articles. There are precedent cases saying those sort of takedown orders should not be made, Mr. Quill, partner at law firm Thompson Gere, said. The proposed media blackout comes ahead of an application to indefinitely delay the trial. They are 2 of 4 applications Mr. Luman's defense team is pushing to reduce the risk of prejudicing the case, in light of the publicity the allegations have received. Crown prosecutor Shane Drumgold said the foreshadowing of the stay application itself would generate significant publicity, and in the interest of a fair trial applied for Ms. Higgins' name, which seems to be the searchword for most of these things, to be suppressed. The pre-trial publicity will either negatively impact the credibility of the accused, or positively impact the credibility of the complainant in some prejudicial way, Mr. Drumgold said. However, Mr. Campbell disagreed, saying publicity of concerns about the fate of the trial can only aid the manifestation of justice, not interfere with it. Ms. Higgins publicly alleged in February 2021 that she was sexually assaulted by Mr. Luman on March 23, 2019, in the Parliament House office of Minister Linda Reynolds, for whom they both worked at the time. Her allegations sparked a national conversation about the treatment of women and their involvement in politics. Mr. Luman has denied the allegation and a 6-week trial is set for June. Former Liberal staffer Bruce Luman has been committed to trial in the ACT Supreme Court. Credit, last week Chief Justice Lucy McCallum warned the more people kept talking about the case, the greater the risk of the case being halted. A man has been accused of a very serious offence. It is an offence that can only be tried with a jury, Chief Justice McCallum said on March 10. She warned public statements made before a criminal trial that might interfere with the administration of justice risked being classified as in contempt of court. She said at the time she did not think there's doubt in anyone's mind as to what would be the basis of the stay application. Last month, Prime Minister Scott Morrison made a personal apology in Parliament to Ms. Higgins for the terrible things that took place here, as part of a first step in reforming parliamentary culture following a workplace review by Sex Discrimination Commissioner Kate Jenkins. Another of Mr. Luman's lawyers, John Corn, last week expressed fear about the Safety Respect Equity campaign involving Ms. Higgins, former Australian of the Year Grace Tame and other high-profile women, going ahead. Mr. Call said the law allowed for the general public discussion of matters of public interest to continue, even when cases are going through the courts. The Chief Justice refused Mr. Drumgold's application on Wednesday but said she could revisit the matter when it returned to court. It may be that publication of the prospect of a stay application by an accused in a trial of this nature will reinforce the remarks I made last week, she said. In refusing the Crown's application, I would not wish to be understood to give free license to the press to say whatever they wish to the public. The matter will return to court on April 1. Thank you for reading the Herald. This article is complimentary. Register or log in now to read more articles and unlock extra benefits. No payment required. Read more. Continue with Google, continue with Apple, or email address. Continue by continuing. You agree to your personal information being collected under our